The unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut said not. During those months or years of appeal, I'm going to restrain Trump from deploying the National Guard. This Court of Appeals is saying, nope, we're not doing that. We're throwing out that restraining order. And during the months and years of argument on the merits, Trump will be allowed to deploy the National Guard. Of course, he's only calling out the National Guard for 60 days. 60 days. So it all becomes rather moot on the merits anyway. Is beyond judicial review. The unelected Black-Robe tyrannical inferior district trial court judges literally have no power here. They have no authority at all. The state of Oregon and the city of Portland claim that Trump's actions calling out the National Guard are ultra vires, meaning in violation of the law, without lawful authority. Whether Trump has shown a likelihood of success on the merits of the plaintiff's ultra vires claim turns on whether the president's determination under 12063, unable with the regular forces to execute the laws, reflects a colorable assessment of the facts and law within a range of honest judgment. In other words, as I said earlier, if Trump has the authority under 12406 to call out the National Guard, every one of these complaints by Oregon and Portland goes away. Trump's authority under 12406 destroys every objection they have. While the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut cited this highly deferential standard, she said, I have to be super deferential to the president. She failed to actually apply the standard. This is very offensive language for a court of appeals to use towards a federal district court trial judge. She just failed to do the right thing. Instead, the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut substituted her own assessment of the facts in place of the president, the Article 2 executive branch, president, commander-in-chief's assessment of the facts. This is the opposite of the significantly deferential standard of review that applies to the president's decision to invoke 12406 and federalize the National Guard under our earlier decision of Newsom. First, now they go through the many ways this unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut effed up this call. First, the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut committed error by determining that the president's colorable assessment of the facts is limited by undefined temporal restrictions to certain specific days, and by the court's own evaluation of the level of violence necessary to impact the execution of federal laws, that the judge gets to make the call. Thus, the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut determined that she would apply Newsom, the Court of Appeals, deferential colorable basis standard to the facts as they existed at the time the president nationalized the National Guard, federalized the National Guard. The unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut then discounted the violent and disruptive events that occurred in June, July, and August, including the closure of the ICE facility for over 3 weeks in June and July, and that idiotic Judge Karen Immelgut focused on only a few events in September. So the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut discounted most of the evidence of events in Portland from June through September. Now, they're criticizing her, and they put a bunch of this in footnotes. Footnote 9, footnote 10. And I rarely read the footnotes, but I think these might be juicy. So let's go ahead and take a look. Footnote 9. The unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut did not define what period of time would be encompassed in an assessment of the facts, quote unquote, at the time of the president's federalization order. Instead, it cited Newsom as considering facts leading up to the president's order, and then referred more generally to days and weeks leading up to that order. It's unclear what facts may be considered under Judge Carol Immelgut's standard to determine whether there is a colorable basis for the president's decision. This is just the Court of Appeals here saying that, listen, we can't just let these judges cherry pick whatever window of time they want so they can fail to find facts that justify the president's calling out the National Guard. Footnote 10, the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut also committed clear error in characterizing the events in September leading up to and preceding the federalization order. There were numerous instances of violent and disruptive behavior at the ICE facility in September. On September 1st, 200 protesters were disrupting operations. ICE had to conduct several pushouts, arrested protesters, had to deploy gas to clear the front of the building to move vehicles. On September 6th, there were 50 to 60 very active protesters that FPS had to push out to get vehicles to enter the facility. On September 12th, protesters delivered a large quantity of sticks and bats, clearly implements of First Amendment free speech, outside the facility. On September 19th, there was a threat that a bomb would be detonated. And although the attack did not occur, it required increased security and diverted agency resources. That same night, 50 protesters outside the facility, black blockers, this is Antifa stormtroopers, were reported assaulting people, including a journalist. I think this journalist was at the roundtable Trump held recently at the White House. And there was disturbance outside the building, and FPS deployed munitions to break up the crowd. On September 27th, there were 50 to 60 protesters blocking the driveway, refusing to leave, many dressed as Antifa stormtroopers in the Antifa uniform with helmets, masks, and personal protection equipment. While the factual background above more thoroughly details these events, even a cursory glance at the facts shows that the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut committed clear error by simply discounting these facts when it concluded that the president did not have a colorable basis for calling out the National Guard. All right, that's it for the footnotes. The Court of Appeals now says, Section 12406 does not carry any such temporal limitations. By its plain text, 12406.3 requires only a determination that the president is unable, with the regular forces, to execute the laws of the United States. The statute delegates the authority to make that determination to the president and does not limit the facts and circumstances the president may consider in doing so. Indeed, the inherently subjective nature of this evaluation demonstrates the president has the authority to identify and weigh the relevant factors under 12406.3. The president can and should consider the totality of the circumstances when determining whether he is unable, with the regular forces, to execute the laws of the United States. Rather than reviewing the president's determination with great deference, as we had ordered in the Newsom decision, the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut substituted her own idiotic determination of the relevant facts and circumstances. That approach is clear error under Newsom. Our dissenting colleague, remember, this is a 2-1 vote, so the one dissenter also wrote in this opinion. Our dissenting colleague takes a similar approach. In other words, makes the same idiotic error. The dissent argues that the plain text of 12406.3 confines the president's inquiry to present circumstances because the statute lacks any forward-looking language, as seen in 12406.1, invaded or danger of invasion, or subsection 2, rebellion or danger of rebellion. That observation, however, does not resolve whether the president may also consider past events. All three statutory prongs are the same as to whether prior events may be considered. So the argument here would be if 12406(3), the president's unable to execute the laws, that doesn't say the president might find himself unable to execute the laws, right? Sections 1 or 2 say that there's an invasion or a risk of invasion. And Section 2 says rebellion or danger of rebellion. Section 3 doesn't say unable or danger of being unable. It's not forward-looking, but they're all backwards-looking. The president is entitled and indeed duty-bound to evaluate the entire context of events leading up to a decision to invoke 12406 as part of the constitutional command under Article 2 that he take care that the laws be faithfully executed. Considering the totality of the circumstances, there is a colorable basis for the president's determination that he's unable, with regular forces, to execute the laws of the U.S. Second, the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut committed error by placing too much weight on statements the president made on social media. So the TDS-afflicted Judge Karen Immelgut obviously doesn't like Trump's hyperbole on social media. Judge Karen Immelgut interpreted Trump characterizing Portland as war-ravaged as the equivalent of the president ignoring the facts on the ground. So the Judge Karen Immelgut relied on these statements to disregard other facts that do reflect a colorable assessment of the facts and law within a range of honest opinion. This was error for two reasons. It was doubly idiotic of Judge Karen Immelgut. For one, under our Newsom decision, we consider whether the facts provide a colorable basis to support the conclusion that the executive branch is unable with the regular forces to execute the law. Even if the president may exaggerate the extent of the problem on social media, this does not change that other facts do provide a colorable basis to support the statutory requirement. For another error, the president's social media post characterizing Portland as war-ravaged may reasonably be reviewed as part of his assessment under 12406(2)'s rebellion prong, which we do not reach here. They do not analyze that here because they resolve this all with subsection 3. Moreover, 12406(3) cannot be analyzed solely based on external protest and violence. We and the president must also consider the president's internal assessment of its ability to enforce the laws. The record reflects that 115 federal officers, nearly 25% of the officers available nationwide, were diverted to Portland. The president may reasonably rely on this evidence in determining whether he is unable to execute the law with the regular forces. The dissent here only reaches a different conclusion by characterizing this evidence as, quote unquote, stating difficulties, and committing the same error as the idiotic Judge Karen Immelgut in discounting, minimizing, and discrediting Trump's undisputed evidence on this point. While Trump bears a burden, the dissent demands, as did Judge Karen Immelgut, far more than what is required to support a colorable assessment. And that, again, is error under Newsom. A third idiotic error by Judge Karen Immelgut was concluding that the surge deployment of FPS officers and HSI officers from around the country to respond to months of violence at the ICE facility established that the regular forces were able to execute the laws of the U.S. This conclusion can be reached only by overlooking the record. While the record establishes that FPS deployed many officers to Portland, nearly 25% of the agency's capacity working 12-hour shifts, 7 days a week. It also establishes that these deployments were irregular, not regular forces, and unsustainable. Trump submitted sworn declarations from Robert Cantu, the deputy director of FPS, and Camilla Wamsley, the DHS field officer, stating that these surges and assignments strained resources and were unsustainable. I'm going to skip over this. We'll just take them at their word. Disregarding this uncontested evidence, Judge Karen Immelgut rejected Trump's argument that the president had a colorable basis to invoke 12406(3) because, under the court's own assessment of the facts, these deployments demonstrate that federal law enforcement officers, unaided by military forces, were capable not only quelling the violence, but also preventing it through September. But the unelected Black-Robe tyrannical inferior district trial court judge Karen Immelgut turned the proper analysis on its head by interpreting the modest improvements created by the surge, by interpreting that as demonstrating the president did not have a colorable basis for invoking 12406(3) and discounting that the surge of officers was inherently irregular, not the regular forces. Judge Carol Immelgut accorded no deference to the president's determination that he could not execute federal laws with the regular forces. So, considering the totality of the circumstances from June through September and applying the required highly deferential standard of review, we conclude the president's assessment of the situation in Portland, specifically the threat to federal personnel and property, and the resulting inability to execute federal law with the regular forces, reflects a colorable assessment of the facts and law within a range of honest opinion. Therefore, Trump is likely to succeed on the merits. And that means the plaintiff's ultra vires claim will fail. It means their 10th Amendment claim will fail, because the 10th Amendment says the rights not delegated, the powers not delegated to the federal government are retained by the states. But if 12406 does in fact delegate this power to the president, which this court just concluded it did, then the 10th Amendment has no place here. So I can skip that. The remaining stay factors, apart from likelihood of success on the merits, we consider whether Oregon or Portland will be irreparably harmed absent a stay, and where the public interest lies, and whether the president will be irreparably harmed. In Newsom, the prior Court of Appeals decision around the activation of the California National Guard in California, in LA, in Newsom, we concluded that both irreparable harm and the public interest weigh in favor of Trump, who has an uncontested interest in protecting federal agents and property and in the faithful execution of federal law. Here, like in Newsom, the undisputed facts show that protesters damaged a federal building, leading to its closure for over 3 weeks, attempted to burn the building down, placed chains on the doors, attempted to breach the front door of the building, broke the front glass, threw objects at the building, including rock sticks and a mortar, launched M80 fireworks at federal officers, assaulted officers, shined lasers at their eyes, doxed officers. The federal government's interest in preventing incidents like these is significant. The dissent, however, argues that Trump faces no irreparable harm because the second temporary restraining order, which is not before us because Trump did not appeal it, still prevents Trump from deploying the National Guard. But this argument lacks merit. Judge Karen Immelgut stated that it granted the second TRO based on the same legal reasoning for the first TRO. Defendants, Trump is thus correct that the first TRO and the second TRO rise or fall together on the merits of the issues raised in this motion to throw out the first TRO. If the first TRO goes, the second TRO has to follow. The dissent does not challenge that common sense conclusion. Whether the second TRO could be extended to preclude the deployment of members of the California National Guard is a separate issue, but this provides no basis for the dissent's conclusion that Trump is not harmed when he's prevented from enforcing federal immigration law by federalizing and deploying members of the Oregon National Guard. Oregon and Portland argue that the other stay factors weigh in their favor. They say that although Trump has an interest in protecting federal agents and property and the execution of federal law, they argue that Trump will not be irreparably harmed in the absence of throwing out the restraining order because any threats to federal agents and property have been remedied by federal civilian law enforcement with support from state and local enforcement, but the record establishes that the continued deployment of FPS to Portland is unsustainable. and state and local law enforcement have been unwilling and unable to assist the federal government's efforts to protect personnel and property at the ICE facility. Finally, Oregon and Portland argue that they will suffer irreparable harm because of the federalization of the National Guard over the governor's objections, because it will result in the diversion of Oregon National Guard members from their state responsibilities and threaten irreparable economic and financial harms to Portland and Oregon and their residents. As we stated in Newsom, while Oregon and Portland have significant interest, their arguments are, in essence, a merits argument that we have already resolved. The Constitution assigns the power to call forth the militia to Congress, and Congress has delegated that power to the president. Therefore, Oregon and Portland's arguments on the remaining state factors rise and fall with their argument on the merits, and because we've concluded Trump is likely to succeed on the merits, in other words, 12406.3 does authorize his activation of the Oregon National Guard, Oregon and Portland fail in arguing harm. For these reasons, we grant Trump's motion for a stay, throwing out the TRO pending appeal, and Trump is now allowed to activate and deploy the Oregon National Guard to Portland. And that's the majority decision. That's the victory for Trump. Now, we do have this excellent concurrence by one of those two judges, Nelson, who would go even further. Nelson argues in his concurrence, which is only him. It's not two judges here, so it doesn't have precedential value. It's not a majority. But he's just saying, if it were me, I would not only agree with this outcome that Trump did legitimately, under 12406.3, activate the Oregon National Guard, but I would go a step further and say that we as federal judges have zero authority to review that decision by the Article 2 Executive Branch Commander-in-Chief. And that's what he's going to argue here over about 20 pages. 20 pages. Let's see if he says it here quick. Yeah. Under current Supreme Court precedent, precedential determinations under 12406 are not reviewable by the federal courts. That's what he's going to argue in this concurrence. But this concurrence is not going to be read during the main part of this show. That's available to everybody. And thank you so much for being here. And I will address the super chats. The concurrence in which a federal judge argues that the federal courts have no role in second-guessing President Trump's activation of the National Guard. We're going to cover that in the bonus show. The bonus show is for members only. So those of you who are members will be able to join us there. In fact, I'll put the link for the bonus show in the chat right now. It's also in the description. And I do set up an auto redirect, but it sometimes doesn't work, folks. So the link for the bonus show is in the description. It's in the chat. I just added it. We're going to be shifting over there in just a moment. It's dirt cheap to be a member, folks. It's only 16 cents a day to be a member, $5 a month. And you get double the Andrew Branca shows for 16 cents a day. So I hope to see all of you over there.